talked about earlier about you waiving your appearance? And you agreed to do as such. So we're going to continue the exam. You can log off if it's permissible with the judge.
Yeah, he's free to go.
I don't know if you can.
He can hear us. I think he's muted, so we can't hear him.
Oh. Judge, you want to let him know?
There he goes.
Can you hear us now, Mr. King?
Yes,
Okay, my understanding, or obvious as apparent to the court, that you are right now in the hospital and you've counseled with your attorney, and you're going to waive your appearance for the remainder of the exam, which I think is about to wrap up shortly anyways.
yes, Your Honor.
Good luck to you, sir. Hope you get better soon.
Thank you, Your Honor.
You can log off.
Thank you.
Thank you.
Okay. On the record, in the matter of the people of the state of Michigan versus Stanley Grodd, Timothy King, Kent Vanderwood, 23-02213, 2216, and 2224. Council appearance.
Good morning, LaDonna Logan on behalf of the people.
Good morning, Your Honor. Kayla Carino on behalf of the people.
Morning, Your Honor. Derek Wilchinski on behalf of Stanley Grote, who's sitting right behind me.
Mike Smith appearing on behalf of Timothy King.
Morning, I'm Michael Bowe and Brian Lennon on behalf of Mr. Vanderwood, who waived his presence. Just to alert the court, Your Honor, Mr. Lennon and I confirmed our client. Mr. Lennon has another court appearance to get through at 10:30, and our client is comfortable with back over the
Your client, what?
Or we discussed with our client, he's okay with the fact that Mr. Lennon is going to.
Sounds good.
Thank you. Thank you.
Any other preliminary matters before we do redirect?
Not from the defense, Judge.
Your Honor, I was just going to indicate for the record that before we called the case, Mr. King waived his right to be present, and I don't believe that that was technically part of the transcript. Unless, okay, so I just wanted to make a record that he did indicate that he was waiving his.
Thank you. Mr. King was present from, I think, the emergency room at University of Michigan.
That's correct.
And currently being treated. He's counseled with his attorney and they've agreed to waive his appearance for the remainder of the examination. And so any other preliminary matters?
No, Your Honor.
Okay. We call Mr. Sharp or Agent Sharp. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do, Your Honor.
Thank you. So you can direct.
Thank you. Agent Shock, I want to start this redirect by talking about questions that you were asked about intent and knowledge of these specific defendants, Mr. King, Grote, and Vanderwood. Do you remember that line of cross-examination?
Yes.
And specifically, I want to ask you, in your review of the social media returns, did you find any evidence that any of the three defendants in this exam had knowledge either that the results were final, that the results would be final prior to December 14, 2020?
Yes.
Which returns?
Mr. King's and Mr. Grote's.
And what was that evidence, sir?
It was again, it was a message that was sent and received indicating that the results of the election were going to be final. It was November 14th, November 15th. Those messages were sent and received, and also a message about a media release of Mr. Okay, Mr. Speaker of the House, Lee Chatfield, and Senate Majority Leader Mike Shirkey indicating that they weren't going to intervene.
Okay, and
Judge, I'm just going to object on the part of the defense when he's talking about this hearsay. He's referencing documents that could be introduced in evidence. We would have an opportunity to look at those documents and review them. He hasn't done that. Prosecution.
well, this is effect on the listener because we're talking about in knowledge that they would have, not that what they the information they received was true.
Well, regardless, Judge, Mr. Schock is testifying to something that we can't cross-examine him now. He's saying he looked at social media returns, and these social media returns indicate something. We can't look at them. There's no foundation, first off, and what he's referring to are hearsay documents. Then, for the truth of the matter asserted, clearly.
So it's not enough for the truth of the matter, sir.
And these documents were provided and discovered.
I understand, well, Judge, we received over 10,000 pages of documents. With all due respect to Ms. Logan, clearly it is for the truth of the matter asserted, because she's asking Mr. Schock, and he's testifying as to affirmative information that our client supposedly received. We have a right to have those documents present, and for him not just to reference them, because right now they exist in a vacuum.
You don't have a right to have every document that's referenced present at the time of the preliminary examination. That information was turned over as part of the discovery. Discovery was extensive, and I recognize that. We even put out dates because of the time it was going to take for the discovery to be reviewed. In addition, the social media returns have been referenced in the other two iterations. So I don't think it was a surprise that it was going to be brought up today.
Well, with respect to Mr. Grout specifically, that hadn't been mentioned in other iterations. Secondly, though, from a foundational standpoint, Ms. Logan hasn't established foundation for Mr. Schock to be able to testify to these social media returns. What he's saying is, I saw something out there without us having the opportunity to review specifically what's at issue. I had filed a bill of particulars asking for all of the information in this case as it pertains to Mr. Grout with some specificity. Received nothing back. In fact, I was told basically to go jump in a lake, that wasn't called for. So
Not that language.
no, of course not. I'm being a little facetious. Ms. Logan and I get along. So, but my point to this is that without seeing these documents, I can't cross-examine Mr. Schock specifically about it. So we have a hearsay problem and we have a foundational problem.
Judge, I agree with, I concur with the objection from my client.
One, it's not hearsay. And this was, well, the returns were referenced on direct, and then this is specifically addressing questions that were asked on cross-examination, which I'm allowed to redirect on that. And I'm not limited to just admitted evidence. I'm allowed to reference any part of the investigation or discovery and redirect.
I agree. The objections are overruled.
My next question was with regards to,
I don't know if I heard his answer. Oh, I did. It was about the returns. Okay, continue.
you said that you saw a post sharing the Shirky Chatfield statement. In whose return was that post observed?
I believe that was Mr. King.
Thank you. Do you recall the date of that post?
It's November 23rd, 2020.
Thank you. Now I want to draw your attention back to a line of questioning asking about People's Exhibit 28. And that to you as a point of reference. Your Honor, I do have a copy of that document if the court wants to refer to it.
Yes, please.
Now, during cross-examination, you were asked a series of questions about how that document came to be presented at the December 14th, 2020 meeting. And a lot of that centered around Mr. Troy Hudson. Do you recall interviewing Troy Hudson in March of 2023?
Yes,
And during that interview, was there discussion about this document and how it came to be produced at the December 14th, 2020 meeting?
yes.
And what was that information?
He received it, I think from Stu Sandler. He wasn't sure if Stu Sandler or Laura Cox who created it, and then he presented it to or handed it to Kathy Burton.
And specifically looking at Exhibit 28, would you consider that language contingent?
I'm sorry, what was the question?
Would you consider that language contingent? And I'll follow up with
Would
another
you
question.
consider that language contention?
Contingent.
Contingent.
Yes.
And could you explain for the record why?
It says here that they're available to meet and perform their duties as presidential electors. And they would cast their votes for Donald Trump as president of the United States and Michael Pence as vice president.
So
So they would, that being contingent, contingent language. So,
and how many signature lines are on exhibit 28?
there's one.
And looking at, I think, defense exhibit A, during your investigation, did you learn that that document actually was signed on December 14, 2020?
Yes.
And it was signed by whom?
Kathy Burden, and then notarized by Henrietta Toe.
During the course of your investigation, did you learn whether or not exhibit 28, well, it's defense exhibit A, was there ever an attempt to deliver that document to the state capitol?
I found no evidence of that.
Was that document sent to the National Archives of the US Senate?
I, again, didn't find any evidence of that.
And I'm going to draw your attention to People's Exhibits 10 and 11. And looking at Exhibit 10, what is that, sir?
Exhibit 10 is the records from the National Archives, and it includes a certification of the records. So when I say the records from there, it's a photocopy of a label and then the memorandum and certificate of votes for the 2020 electors from Michigan for the Republican Party. Yes, and then the mailing label with the tracking number on it. Again, it's a photocopy of that.
And Exhibit 11, just describe that briefly for the record.
Yes, it's the memorandum and the certificate of votes for the 2020 electors from Michigan from the Republican Party for President Donald Trump and Vice President Michael Pence.
And other than the fact that Exhibit 10 has a certification from the National Archives and has, I think, the shipping label, are the documents enclosed the same certificate of votes for the 2020 electors from Michigan document?
Yes.
Now, during your investigation of that document contained in Exhibit 10 and Exhibit 11, were you able to determine whether or not that was an actual certificate of votes for the state of Michigan?
Yes.
And what was your, what was the determination from your investigation?
It was not.
And how did you determine that?
By verifying that with the Secretary of State, Michigan, looking at the documents. Also verifying that with the National Archives and the Office of the U.S. Senate.
I'm going to hand you what has been marked at, well, admitted as People's Exhibit 6. What is that document, sir?
Can you identify what exhibit 6 was, just so?
I'm going to have him identify it.
It's the this is the legitimate or authentic certificate of votes from the 2020 presidential election for the electors, the Democratic electors, signed on the 14th day of December 2020.
And do the names and signatures on Exhibit 6 correspond with the state of Michigan certificate of ascertainment for 2020?
Yes.
Published. Yes. Now, Exhibits 10 and 11, does that document contain contingent language?
No,
And how many signatures does the document contained in exhibit 10 and 11 require?
how many does the
Signatures.
signatures or 16 signatures on it? That's not including the vacancy signatures. There's 2 pages that have 2 signatures on that as well.
Now, looking at exhibit 11, the second page, I believe the title is Certificate of Votes
Yes,
of to the 2020 electors from Michigan.
yes,
Is there language on that page that is not true?
yes,
Can you identify what that language is for the record?
yes. It's the language that says being duly elected and qualified electors for president and vice president of the United States. And then we convened and organized in the state capitol at 2 p.m. on the 14th day of December.
Does that page also indicate that the undersigned are actually voting?
Yes, I'm sorry. Yes, it does. Yeah. So cast our votes for president and vice president.
And throughout the course of your investigation, did you find any legal means where the non-winning candidates for elector could cast electoral votes for the state of Michigan?
No,
Now, referring to exhibit 24, which was an email sent from Kenneth Chesbro to Marion Sheridan containing a template for the certificate of votes, was there language changed from that document to the final document?
yes,
And was that change in language significant?
yes.
Well, how was that significant to your investigation, sir?
Because it demonstrated that somebody had altered the language from the document, People's Exhibit number 11. And it's the language in Mr. Chesbro's document said that they met in the Senate chamber, and also had, and it had Marion Sheridan listed as the secretary. And that was changed in People's Exhibit 11 to reflect that Maya Rodriguez was the secretary.
What's the significance of the Senate chamber as it comes to electors voting?
Well, that's where they vote at. That's what the law says.
And for purposes of the record, that is Michigan Compiled Law 168.47. Thank you. On exhibits 10 and 11, is there any language on that document that just says that the persons affixing their signatures are just supporting President Trump?
No. No.
And as far as the information that you gathered during your investigation surrounding the meeting on December 14th, 2020, did you find any evidence that only page 3 of Exhibit 11 was available to the defendants during that meeting?
No.
And what evidence do you have to the contrary?
Like I said, Mr. Renner had testified that there was page 2 and page 3 there. Like I said, Tony Zammit had said that there's multiple documents on the table in the basement. at the Michigan Juvenile Headquarters.
I'm gonna jump over to the cross-examination of Mr. Chesbro's legal theories. Do you remember that line of questioning?
Yes,
During the course of your interview with Mr. Chesbro, did Mr. Chesbro speak specifically about his legal theories and their application to the state of Michigan?
yes.
And what did he say?
Had a chance to review that. He just said that the legal theories, they wouldn't necessarily apply to Michigan because there's a large number of votes in Michigan. There was roughly 150,000 votes. There was no recount as well order and no court order.
And during the course of your investigation, did you learn that the template that Mr. Chesbro created for the state of Michigan was created for other states?
Yes,
Okay. Did you look at those templates from other states?
I did,
And were they all exactly the same?
except for Pennsylvania. I mean, they were all relatively similar, yes. Pennsylvania had some contingent language in there, I believe. There were several drafts of them as well, but they were laid out in a manner that, you know, showed that the electors, the Republican electors from each of those states were casting their votes for President Trump and Vice President Pence.
And only Pennsylvania had contingent language?
I believe so.
Pass the witness, Your Honor.
That was your redirect. Anything relative to your redirect?
Sorry, I just realized I said pass the witness. My apologies. Lots of coffee. Don't
There's
pass.
technically
Yeah, we're
no
not passing the
cross.
witness.
All right.
Yeah, you've already crossed, so
As far
let's,
as I'm concerned, it's a distinction without a difference, Judge.
no, there's a difference.
Depends on what the judge
There's a
allows.
difference.
I guess it's.
We're not reopening cross-exam. It's very limited to what you just questioned that you
yeah.
did not already address.
No, I got you, Judge. Thank you. Mr. Schock, just a few questions over here. With respect to Mr. Chesbro's legal theories, you were just asking, what were the legal theories? I don't know that we've ever gotten those into the record.
No, and I don't recall. There was a lot of discussion about that, but I don't recall specifically what his legal theories were.
You don't know, I'm assuming, whether those legal theories, whatever they are, have any support in the legal community at all, because you're not a lawyer, right?
Yes.
Okay, fair enough. With respect to Mr. Renner and his testimony that pages 2 and 3 were available, there was no testimony that I recall, and you didn't find any evidence that pages 2 and 3 of Exhibit 11 were ever presented at the meeting stapled together as one document, right?
Yeah,
That's
correct.
That's correct.
Yes.
Sorry, I don't want to
Yeah.
go down that road.
Yeah.
So it's possible that they were spread out and not actually attached together.
I don't have any evidence to show that they were stapled together or paper clipped.
You don't know one way or another how they were presented.
No, I do know that they were on the table.
Right,
That's what
whether they were together, you don't know.
When you say together, what do you mean?
Affixed by some
Oh,
type
no,
of
no, I don't.
staple, paper clip, binder clip, something like that.
Yeah, no.
Okay, I think we were on the same page
Yeah.
on that, but I wanted to make sure, so, okay. You had testified that there was nothing that you found in Michigan election law allowing the Republican electors to cast their vote for President Trump and Vice President Pence, correct?
Yeah.
Is there anything that you found in Michigan election law that prohibited them from doing that? Here,
Well-
let me withdraw the question. I'm going to rephrase it so it's easier to understand.
Yeah.
Remember, we talked yesterday about like an affirmative obligation and an implied obligation. We
Yes.
talked about that with respect to intent.
Yes.
Okay. was there any affirmative law that you came across, whether it was under Michigan election law or not, that said that the Republican electors were not allowed to cast their votes for President Trump and Vice President Pence?
So what I found was there was election law that lays out how the party that receives the popular vote casts their votes, but there's nothing in the law that I found that says the Republican Party can't cast their votes. If does that
Well,
answer
sort
your
of.
question?
Here.
I don't.
Let me, you found election law that says that the winning party electors would be casting their vote for their candidates, correct?
Yes.
Did you find anything in the election law that prohibited from the losing party from doing the same thing? Any affirmative law that says you are not allowed to do this?
No.
Okay. With respect to you were asked some questions about Exhibit 28 and whether there was contingent language in here. Recall that?
Yes.
Contingent on what? I don't think we ever got that into the record.
So let me look at the document up here. Yeah.
Let me be clear when I ask the question as you're looking this over. What's the triggering mechanism that would activate the contingency?
It just says that they would cast their votes. They would cast their votes for President Trump and Vice President Pence.
Right.
That there was a meeting that the electors by those electors to recognize and affirm support. So it doesn't. There's no language that says, you know, there's no language that adds on to that.
So there really isn't any triggering mechanism for the contingency, correct?
No, not that no.
All right. You understand what I'm asking when I say triggering the contingency?
No, I don't. So
Let me walk you through.
Okay.
Okay. When I understand, the way I understand contingency and the way I think it actually is that in order for something to happen, the contingency, there has to be an event that triggers the contingency. In other words, if something happens, we will do this, or if something happens, I will do this. Is that the way you understand contingency?
Yes, if
Okay.
A happens, and you know.
Right. What is the A that needs to happen in order for B, we cast our votes for President Trump to be activated?
It's kind of alluding to A, but it doesn't specify A.
It doesn't say anything
It
about
says-
A in there,
No, it
does it?
just says that we are available to meet and perform our duties.
So it's open-ended,
Yes,
totally open-ended.
yes, the document,
Right, in terms of the contingency, the triggering
Yes.
event.
but as I mentioned earlier, the interviews that were done with Laura Cox, this document was created as a result of showing support for President Trump and Vice President Pence. And if something were to happen, she didn't really specify what that was, then.
Did you ask her?
I didn't I don't believe I interviewed her.
Okay, did you come to an understanding as to what if something may have happened was, that it actually was, in other words, what is it, the contingency that they were contemplating?
I don't recall what her statements were.
That would be important to know, wouldn't it?
Yes.
Because you'd want to know what the triggering event was for any contingency. All right, now, just a couple more questions here, Mr. Schock. You had mentioned, Ms. Logan had asked you questions about the element of intent and knowledge by King, Grote, and Vanderwood. And you had mentioned, I think, something new today, but let's explore it to make sure I understand it. You had talked about social media returns that were received on November 23rd of 2020. Recall saying that today?
November 20.
No, he did. He said, that's why I'm asking, because he said November 23rd.
No,
they-
he said that was the date of the post. That's a mischaracterization of his
Yeah, it wasn't.
testimony.
Okay, well then let's clear this up, because I want to make sure I understand it. So yesterday you had testified that King, Grote, and Vanderwood had received social media or had either created and or read social media posts on 11/15. You remember that, November 15th,
Yes,
indicating that yesterday you had testified that Secretary of State Benson was going to certify the election. Recall that?
yes,
Today, I'm understanding your testimony as being slightly different, that King, Grote, and Vanderwood either created or read social media posts that said the results are final, referring to something about State Representative and Senator Shirkey and Chatfield.
no, I said that there's a post that was made, I think it was on Mr. King's social media or meta return that said that, you know, Shirkey and Chatfield, it was the press release from Shirkey and Chatfield indicating that, you know, they weren't going to intervene. And I'm summarizing this, of course, but they weren't going to intervene. So, and that post was, I thought it was November 23rd.
Okay, when was the press release by Shirkey and Chatfield made? Do you know?
There was two. There was one on the 14th, and then there was one in November. I think it was on the 20th of November.
But you don't know off the top of your head.
I can't recall. It was around the mid-November, November 20th. I know that it was shortly after their visit to see President Trump at the time.
How do either of those social media posts, the one on the 15th you described yesterday or the 23rd today, how do those show an intent to defraud? In what way?
Your Honor, that exceeds the scope of my redirect, because I was talking about knowledge.
No, she asked specifically about intent to defraud. That's how it was introduced.
No, knowledge.
Knowledge. Do not discuss intent.
Not- Well, okay, let me ask you this. How does that, I wrote down intent and knowledge of King, Grote, and Vanderwood. So, you know, maybe I wrote down the wrong term, but I was pretty confident about it. So, all right, let's just talk about knowledge. What are you claiming that those social media posts reflect with respect to knowledge? Knowledge of what?
Just the knowledge of what's going on in the media.
And how does that have any impact on the election whatsoever?
Well, it shows that the election is the election is being finalized, and that there's not going to be an intervention from the state legislature. That's it. So it's just information that was on their social media posts, whether
Okay.
received or posted themselves or passed along, shared. It's just information that's on there that indicates that the state legislature is not going to intervene and that Benson is going to finalize the election. So that's all.
All right, I believe in your affidavit. We talked about this during my cross-examination of you, but in your affidavit, you had put in there something different. So tell me which one it is. In your affidavit, it says that the House and, according to Shirkey and Chatfield, the House and Senate would not be taking action to contest the electoral vote. That's a little different, isn't it?
Yeah, and I'm gonna object. This was gone, addressed in cross, and it actually exceeds my redirect.
Well, I could, Judge, I think I'm certainly allowed to dig into this question of knowledge, because the basis for what Mr. Schock is claiming, the knowledge of Mr. Grote, Mr. Vanderwood, and Mr. King are, is from this statement from Mr. Shirkey and Mr. Chatfield, which I believe is different than what he put in his affidavit. So this is my last question too, so.
Yeah, because typically, I'm telling you how I typically run things. I don't give
I know you don't.
I don't give a recross
I
after
appreciate it.
for an exam.
I appreciate it.
So I'm gonna allow this last question and then we gotta move on.
So as I'm recalling this social media stuff, I'm recalling it from memory. I'm summarizing what
I
I
understand.
put in the affidavit. So that's what I mean is what's in the affidavit. Maybe my choice of words isn't exactly the same, but I mean the same thing. It's the Shirkey and Chatfield announced that there wasn't gonna, they weren't gonna intervene, or now I'm trying to remember
Let me help
my
you out.
memory, but you can read it.
it says that would not be taking action to contest the electoral vote.
Yeah.
That's obviously different than saying this is final, we're not going to do anything in the future, right? That could change over time.
Yes,
And I
but
believe that mischaracterizes the testimony, and correct me if I'm wrong as to what the court heard. There are two different posts. There's the post about the Shirky Chatfield statement that says they're not going to do anything. And then there's a separate post that says Benson is going to finalize the results.
And I'm talking about the Shirky Chatfield post that Ms. Logan referenced in her direct.
Which does not say anything about finalizing the results.
But that's what the witness testified to. So the question was asked, the witness testified to something, and now I'm being told that, apparently what I'm being told is that the witness was wrong in what he had said.
That's not what the witness testified to.
I think she's saying that mischaracterizes what he said.
But he did testify that the results were final based on a statement made by Shirky, and I don't mean to sound rude by not using senator and representative, but I just don't remember which was which. So I don't mean to do that. So that's what the witness testified to. And all I'm asking is if the statements by Mr. Shirky and Mr. Chatfield were consistent with what was in the affidavit. And the witness has already testified and said, I may have had my language wrong. And I'm just trying to, my last question is to put a finality on this question regarding the language. That's all. That's all. It's just different language. And it was introduced by the witness himself, not by me, not by even by Ms. Logan.
Well, I think the council is combining two separate posts, and that's why I'm saying it's a mischaracterization of the witness's testimony.
We'll let Agent Shaw clarify for us.
Yes, thank you.
Thank you.
You understand the post we're talking about today, right?
so we're talking about, are we talking about the Shirky? Because I'm confused myself. We're talking about
Okay.
the Shirky Chatfield post or the Benson post? Because
You tell me, you had testified earlier today that there was a post, you believed it was on the 23rd, which I'm taking to be different from the Benson post on the 15th.
yes,
Right, okay. And in this post regarding Shirky and Chatfield that was placed on Mr. King's social media, you believe that this indicated knowledge because Shirky and Chatfield said that this was final and they weren't going to take any further action, right?
yes.
Okay, that's different than what you have in your affidavit where they said that there was no further investigation, right?
Yes, but as I said, I was summarizing, so whatever,
got it.
I can't, I guess what I'm trying to say is, I can't recall the exact language.
That's
And
all I'm asking.
So, yes, I can't recall the exact language, but
So
it was,
if
the
the language in your
affidavit,
affidavit, it
yes.
would be different. Got it,
Yes.
okay. There's no evidence that my client saw this post from Mr. King, correct?
no,
Thank you. Nothing further. Sorry for the confusion,
No.
Mr. Shock.
Good morning, Mr. Shock.
Good morning,
Mike
Mr.
Smith, on behalf of Mr. King. You made a comment that Mr. Zamet told you in an investigation interview that he saw multiple documents in the basement. Is that a correct statement?
I think it was multiple pages,
Multiple pages.
yes.
Do you know if Mr. Zamet was present in the basement on December 14, 2020?
Yes.
And how do you know that?
Oh, God.
Okay. And did he describe the multiple pages of those documents, or did he describe the documents, what they were?
No, I don't believe so.
You never asked him?
No, I believe I asked him. I don't believe that he
And
was
he
able
doesn't-
to describe it.
Okay, so you didn't recall? Would that be a fair statement?
Yes,
Okay. And you don't have any evidence that Mr. King reviewed or read any documents there in that basement on that day. Is that a correct statement?
no, I mean.
That's not a correct statement?
No, it's not. I don't believe it's.
Okay, what evidence do you have that Mr. King reviewed or read any documentation in that basement?
Just the document with the signature on it.
So just that document?
Yes,
So you don't have any evidence that he read or reviewed any other documents in the, allegedly in that basement, with the exception of one that had a signature page?
yes,
And you previously testified that you don't have any knowledge of whether or not those pages were stapled together, paper clipped together, or somehow cohesive together. Is that correct?
That's correct.
No further questions, Your Honor.
Morning, Mr. Shock.
Morning, Mr. Vogel.
I'm redirecting the emanation. You were just asked about the Pennsylvania alternate slave election. Do you recall that?
Yes,
And in your investigation, speaking to Mr. Chesbro about his legal theories, which you were also just asked about, right?
yes,
You reviewed a number of communications and other documents about all the different slates from Michigan, Pennsylvania, New Mexico to Arizona, Nevada to Georgia, right?
yes,
All led by the Donald Trump campaign.
yes,
Donald Trump himself.
yes,
And you recall communications specifically about what they wanted to do in Pennsylvania, didn't you?
yes,
And the concern there was that the electors in Pennsylvania had more knowledge about what was going on about this plan to submit the document elsewhere, correct?
yes,
And so they reached out and they asked questions. The questions Mr. Renner testified yesterday, he didn't have the opportunity to ask. Remember that?
yes,
Because in Michigan, like Mr. Renner, they were not made aware of that plan. Your testimony yesterday was that you had no link between Kenneth Chesbro and my client, this legal plan, correct?
Your Honor, I'm going to object. This is going to cause for speculation.
Want to respond?
I believe I just asked him to confirm his testimony from yesterday, Your Honor, which like there was no link between Kenneth Chesbro and my client.
No, the question was that the electors, the Republican electors were not made aware of the Chesbro Republican Party plan. That caused for speculation.
I can ask it in several other questions, Your Honor, just as I did yesterday. He has no evidence or witness going to come and testify that my client reviewed the document.
That's different.
Those things. I can do it that
The
way.
way formulated matters.
I have no problem doing that. Your Honor.
Objections
I'm just trying to move this along. That's all
I
it is.
understand.
Okay, so again, with regards to Kenneth Chesbro, my client, and Kenneth Chesbro's legal theory and plan, you do not have a witness who will come in and testify to say that my client was ever made aware of that plan, correct?
correct,
There is not a witness or a document that will confirm that my client ever reviewed any documents, altered or not, by Kenneth Chesbro or anyone else from the Donald Trump campaign.
just the one with his signature on it.
I don't know, I'm asking you, is there someone who's going to say that they saw him sign that document?
No. I thought you were asking me something different, if he reviewed it. No, if I have a witness that saw it, no.
No, these other folks, these other witnesses, like Mr. Renner, they don't know if they saw him sign it, review it, read it, or that he was ever presented with it.
That's correct.
Now, you recall conversations between Mike Roman and Kenneth Chesbro specifically about the Pennsylvania electors and what the changes they wanted to the document.
Yeah, this exceeds the scope of redirect.
The Pennsylvania electors did not come up at all, Your Honor, and still correct examination. I did not ask those questions.
I didn't
I
even,
didn't talk about the electors.
We talked about where there was contingency language in Pennsylvania electors document. Your Honor. That was the first
right,
time that came up,
agreed.
was on
And your
redirect.
question is
I just wanted to
about the
get into
contingency language in the Pennsylvania?
that. How that change was made, because it's different than what occurred in Michigan, Your Honor.
How-
There's direct evidence that explains that, I think, in the best light.
Well, your question was about the electors wanting to make changes. I didn't talk about the Pennsylvania electors, just the Pennsylvania document.
I think you
Well,
want to know
that's-
why the document had the language it had in it, Your Honor, because it's different from Michigan. And Mr. Renner testified that he didn't get to ask the same questions that the electors in Pennsylvania were able to ask, and they were able to get contingency language in their final version of the document, which didn't happen here in Michigan, because they were not made aware of that plan, and given that opportunity to do so, according to Mr. Renner, according to Mr. Shaw.
That assumes facts, not evidence.
Yeah.
That assumes that they were not made aware of the plan and they just, or that they were not given an opportunity. For all we know, they could have been made aware of the plan and chose not to have contingent language. We don't know.
That's just
Well,
it,
that's
Your Honor. We
important.
don't know, and I think we need to explain why we don't know that.
But what the Pennsylvania electors chose to do, other than what I asked about, which was just the document, is not relevant here. And it's definitely not a subject that was brought up on redirect.
It was though, Judge, if I may, just,
Well,
sorry, Judge.
Standing to
No.
object.
that she asked specifically about whether or not there was contingency language in any other of the documents he said he believed in Pennsylvania. That was very limited. we're not going to delve into what happened in Pennsylvania.
Thank you.
You had the opportunity to do that when you did your cross, you did not.
Well, and I would just say, Your Honor, to make a record, I don't believe the record reflects that anyone brought up Pennsylvania on cross or on direct examination. I don't believe Pennsylvania came out.
Her question wasn't specifically about Pennsylvania. That was he said he believed only in Pennsylvania. He asked about contingency language.
And I appreciate it, Your Honor, I understand. So, Mr. Schock, just to wrap up though, you do not have a witness or a piece of document, there are no emails, there are no social media posts that relates to Kent Vanderwood that are going to make, or, as any sign of proof that he was made aware of Kent Chesbro's plans.
Correct.
And he did not have the opportunity, as far as you know, to ask for any type of contingency language in the document.
I don't know that.
Because we don't know that he was ever aware of that plan in the first place.
What
Kenneth
Chesbro's plan?
Your Honor, this exceeds the scope of redirect.
I have just another question to Your Honor. I'm just trying to finish here.
I'll allow him to answer this.
Yeah, so the question was, you do not have any direct evidence or anything to show whether or not he even knew of Kenneth Chesbro's plan.
Correct.
And Mr. Renner, the state's cooperating witness, testified there were two purposes of that meeting as far as he understood it. And it was to go to the Capitol, or the state legislature, which my client did not do. And the other was to memorialize their votes in case something changed the election.
Your Honor, this definitely exceeds the scope of redirect.
Thank you. Do you have any other questions
I have one more
within
question.
the scope of her redirect?
I have one moment here, I'm trying to formulate what this final question is going to be. I'm getting thrown out here. The questions with the 1 to 2 more questions are just, well, all right, I'll just ask one more question, Your Honor. That is the key, right? My client knew of Kenneth Chesbro's plan, and that's why he signed this document. You don't have proof to demonstrate that he had any knowledge of Kenneth Chesbro's plan.
That was asked and answered.
How is this different from your question you already asked him?
Because it signifies this is the main link between my client and this co-conspirator who led this conspiracy to prevent that plan, Your Honor.
Right, I recognize that that's the information you want, but you've already asked that question. Thank you. May we redirect?
Very briefly.
Getting back to the social media posts, how many posts were you referring to in redirect?
Just 2.
What was the date of the first post? This is just for clarification.
There was one on, November 14th and 15th.
And what was the context of that post?
It had, to summarize that, Jocelyn Benson was about to certify the votes.
And in whose returns did you see that?
Mr. King's and Mr. Groves.
And what was the date of the second post?
It was November 23rd, 2001.
And what was the nature of that post?
To summarize, it just said that Shirky and Chatfield, there was a press release. So Shirky and Chatfield announced that either weren't going to take any action or there was no intervention on the state of from the state legislature.
And in which post did you observe? I mean, in which return did you observe that?
I believe it was Mr. King's.
Do you still have exhibit 28 in front of you?
Yes.
Do you see the second paragraph of that document?
Yes.
Could you read that, please?
All have affirmed that they are available to meet and perform their duties as presidential elector required by the United States Constitution, Michigan State Constitution, and Michigan's Election Code 16847.
Okay, and could you read the third paragraph as well?
All have affirmed that as required by Michigan's faithful electors, provision in MCL 168.47, they would cast their votes for Donald J. Trump as president of the United States and Michael R. Pence as vice president of the United States.
And in both of those paragraphs, Michigan compiled law 168.47 is cited, correct?
Yes.
Object, I asked the answer before, and this is beyond the scope of recross.
Well, recross talked about whether there was contingent language in Exhibit 28.
It's been covered.
Ken Vanderwood knows the objection, Your Honor.
That you were responding to the objection.
This is directly within the scope of recross. They asked if there was contingent language in Exhibit 28, and I'm having it read into the record.
I believe that this was addressed on redirect already. We did ask a couple questions about contingency plans. We were not allowed to get into much more beyond that. I don't believe the state should have another right to ask the same question. These questions were already asked the witness, I believe, on redirect.
That's true, Judge.
Right, but anytime you, this is why I don't reopen for recross, because now I have to let her redirect again.
I'm actually done now.
Thank you. Did we get a response?
Yes,
The objection's overruled.
thank you. No further questions of this witness.
Thank you. If you're shocked, you can be excused from the stand. And that was the last witness.
That was, Your Honor, and the people have one final exhibit that we're moving for its admission pursuant to Michigan Rule of Evidence 202 for judicial notice. It is Timothy King v. Gretchen Whitmer, located at 505 Federal Supplement 3rd, 720. The 2020, actually December 7th, 2020 opinion authored by Federal District Court Judge Linda Parker.
That will be admitted.
Thank you.
Okay. There were, I was told there were no defense witnesses. That has not changed,
That
correct?
has not changed, Judge.
Okay. So, this concludes this iteration of proofs, as decided in the previous matters, there will be bind over arguments in writing. Read those. I think I gave a 50-page limit. Not encouraging 50 pages, but some people requested
Understood,
that.
Judge.
Some people requested that. You'll get the scheduling of that by way of mail, but my expectation is that there will be a bind over argument within the next 30 days in writing.
Judge, if I may, just a couple of issues. First off, I think we're gonna have difficulty doing the argument without the transcripts.
I'm not waiting for transcripts to get bind over argument. Get bind over argument at exams all the time, and you don't have a transcript to do it.
Yeah, I think this is a different case, Judge. I'll just make a record of it, then I request that we get a briefing schedule after the transcripts are produced.
I recognize that you've made the request the same way the other parties made requests to get the transcripts from the first iteration. Before I started the second iteration, it was denied because you don't have a right to that. You also don't have a right to get a copy of the transcript before you make your bind over argument. You can request the transcript, obviously, if the matter is going to get bound over, if you're going to appeal or whatever, but you don't have the benefit of that. And this one being shorter than any of the others, I'm not inclined to carry this matter over any further because this matter should have been wrapped up a while ago. And these three were, remember, I separated this into two factions, not three. And so this was because three of you all failed to comply with the other court dates. And so I'm not going to set this out any additional time.
The second request is Ms. Logan has a copy of all exhibits. I would just request that she distribute them amongst the parties. Email's fine.
I'll put them in a OneDrive,
Yeah, that's fine.
including defense exhibit.
And then my final request is that there were a number of documents referenced over the course of this exam that weren't produced. Obviously, at the end, social media springs to mind. The discovery that was produced in this case, Judge, is almost impossible to go through with any degree of certainty. Folders are named one thing in one request and then a different thing in a different request. There's folders that are called evidence in one production and general in another production. So to find a lot of these, all I'm asking to find these documents is sometimes almost impossible. My request to Ms. Logan would be if, and I'll copy everybody on our group into this, we would make a request if she could forward, for example, I'd like to get a copy of the social media that was referenced. I don't know even where to begin to look. I've looked through every folder. I didn't see it. Most of the time, the social media production is a series of characters that are so long and there's no indication as to what it's actually referring to. So all I'm asking is that upon request, if Ms. Logan could forward those over to us, I would appreciate it.
The social media returns were sent separate from the initial discovery, and they actually identify which defendant's social media return it is. So you have Facebook, Instagram, and Twitter, and they're all identified by.
Are we only
defendant's
discussing
names.
social media returns or some other?
No, any I mean, I have to go through my notes, obviously, but what I'm looking for are the documents, and I think we're almost universally referenced by Special Agent Shock. And I'm not blaming him for it. Obviously, these things just happen. But just for example, to take what Ms. Logan had just said, I agree that some of these social media returns are indicated by the witness, but even within that folder, there may be 30 documents with no indication as to what they're referring to. They are literally like characters that stretch out 30 in length, and it's impossible to find where she knows where they're at. She's referred to them here. I'm just asking as a courtesy that we could have those sent over to us upon request. I may not make that request, but I think it's, I think it's fair.
I would imagine that if you know what documents you're talking to, you could reach out to her and she can direct you. I don't see why that needs to be a formal issue before the court.
I just want to make a record of it because I know all defense counsel have had a difficult time determining where these documents are.
I would
There's-
imagine if there's 10,000 documents.
There's folders, Judge, where, for example, in social media, there'll be 30, I'm guessing it's the number, say anywhere between 15 and 30 files within there. One of the files will actually be a piece of social media, and the other 14 to 29 are returns from the social media company that are somehow duplicated. I'm just
Sounds good. If it, that's noted, your request is noted. I don't,
Thank you.
if it becomes an issue further along the line, meaning
Understood.
you can't find it, then a court will address it.
Understood.
Counsel?
I just had a sort of logistic question for the briefing schedule, Your Honor. I wish to clarify, I believe Your Honor indicated that the bind over briefs would be made within 30 days or.
Bind over, and to be clear, I expect the prosecution to file this first.
And that was my next question for you to do.
Agreed. So I'm not saying that you can't request your transcript. I'm not waiting for the transcript to get here. I expect her to file her bind overs, at least the first set of them. I know she's got to file one for each within 30 days.
Right.
And then once I receive them, 30 days from those receipts, I'll expect responses. Correct.
Okay.
Obviously, she's not going to file 15 at the same time. So.
No, I understand. Sure.
Right, so that's why I said you'll get the order in the mail, because I gotta
Yeah.
lay out how I expect her to have them filed. And then you may, if you make the request today, have your transcript by then, I don't know. But I'm not gonna hold this out until then. We could be here until March if I do that.
Understood.
Any other matters?
No, thank you, Your Honor.
I don't believe so, Judge. Thanks.
Thank you.
I'm sorry, Your Honor, just a point of clarification
Yes.
so that I can plan out my schedule for the upcoming
Absolutely.
weeks regarding the briefing motions, briefs, response briefs, whatever. You've indicated 30 days.
That will be the beginning of the filing. I don't expect you to file all 15 in 30 days.
Okay, and that's fair enough. I appreciate and accept that. But when 30 days are referenced, are you envisioning 30 days from today or 30 days from the date of the order?
30 days from the date of the order.
Okay, very good.
And then obviously there'll be an opportunity if necessary for you to respond to any of their filings.
Outstanding. Thank you, Your Honor.
Oh, thank you.
Good, thank you.
Thank you. And then the prosecution will provide the court with the exhibits.
Yes, of
Okay,
course.
thank you.
We have everything except for Tuesday. Some of them.